Welcome, everyone, ladies and gentlemen, to the January 23rd meeting of the Village of Pinehurst Historic Preservation Commission. The purpose of the commission, just to review, the purpose of the commission is to approve certificates of appropriateness for new construction or major work, and to do so by conducting hearings and findings of fact when applications come before us. Our mission is to take no action except to preserve and approve that which is congruous with the special character of the Village of Pinehurst Historic District. I am Molly Gwynn, the chairman of the commission, and on my right is Eric Von Salzen and Richard Vincent. On my left, Jim McChesney, John Taylor, and Tom Schroeder. Absent today because he is traveling is Terry Lertz. Also with us today from the village staff, Peter Hughes, Darren Burish, Senior Planner, and Kelly Brown, Executive Assistant. We have a quorum, so we can proceed. This is a quasi-judicial hearing, so anyone desiring to testify must be sworn in, and we are required to consider only facts presented in this hearing. The proceedings are video recorded. The first order of business is to review and approve the minutes. Do I hear any discussion on the minutes?
I've got some discussion. I think we've discussed this issue before. Both of the...
Why don't you speak in the mic, yeah.
Sorry. Both of the matters covered in the last meeting have the same problem. We have a section that is called conclusion and a section that is called motion. They're really both properly part of the motion. For example, in the first one it says conclusion, Mr. Taylor stated upon due consideration of the application package submitted and the testimony given, the Historic Preservation Commission concludes the following. That's not a statement of a member, that's a motion that the commission should conclude as follows. So in both instances, in order to have a record that properly reflects what we've done and why we've done it, we need to combine the conclusion section and the motion section under motion. They're both parts of they're parts of the motion that was moved, seconded, and passed in both cases.
So are you saying that you need to move motion up to join the paragraph that marked conclusion?
What I would do is the simplest editing possible would be to change the word conclusion to motion, change the word stated to moved that, and then the whole matter that follows that would all be part of the motion and therefore would be italicized. And where the word motion now appears, I would write, and that the commission adopt the findings of fact, etc., with these conditions and issue a certificate.
Okay. Okay.
Carried by a vote of 6-0.
So what you're saying is the final paragraph then should read motion. Mr. Taylor moved. You could really just substitute the motion paragraph for the conclusion paragraph.
I think that the verbiage that is under the conclusion paragraph is useful, and it's part of what we decided. So I don't want to lose that. But it should be treated as a statement of the motion that was made and voted on.
And of course, if you look at the italicized section, that it really repeats that phrase, satisfied the burden of persuasion.
Yes,
You know.
there is some duplication there.
But I think that's actually okay. Personally, I like Eric's suggestion. I think as I tried to scratch it out as he went along, I think that gives both a clearer statement of what we actually did, and arrives at a conclusion, although we don't have to say it's a conclusion, but clear. There were conditions. We recommended issuing the COA, and the motion was carried by whatever the vote was.
Okay.
I make a motion to table these minutes until the next meeting for corrections.
Tom Schroeder has moved to table the motion.
Second.
Yes, do I hear a second? Eric Von Salzen has seconded the motion. All those in favor?
Aye.
Thank you. So the minutes for the November 21st, no, gosh. December 19th. The minutes for the December 19th meeting have been tabled until our February meeting.
Eric, it might be helpful if you could afterwards or at some point get with Kelly and explain to her what you were saying so that she can make whatever corrections are appropriate.
I've marked it up. I could email it over to you in the next couple of days.
It seems to me that what needs to happen is we need a new template for our motions, and we will just, if we create that, share it with Kelly, and then it'll be, good for the future. Seems to me we've been talking about this before. So,
We have, and we've improved the template a couple of times just in the year that I've been on the commission.
yes,
We need, I think, one more tweak.
okay, so Eric will put your heads together, make the changes. All right. The next order of business, well, we need to open the public hearing. Do I hear a motion to open the public hearing?
So moved.
John Taylor moves to open the public hearing.
Second.
Tom Schroeder seconds the motion. All in favor?
Aye.
And then let me swear you in, Peter, and who will be presenting the case for the first and only case for COA 2019? Okay, well, why don't I swear everybody in at the same time? And, all right. Okay, all right. So, and your name is? Robert Mosbrook, all right, and you're a
Hey,
neighbor.
hold on.
They all need to be on mics.
They need to be on
sworn in.
microphones or we're not going to catch up
Okay,
with this.
well, let's, everybody stand up, and I have two mics, and if you all who were representing the resort, if you will sit at the table, and Mr. Mosbrook, if you will stand at the mic. And maybe we'll get everybody's voices in here.
Sit at the table. Thank you. No, that's all right.
Our staff is in the back going like this.
Okay, all right. So, do you affirm that the testimony you shall give to the commission shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Thank you. So, Peter, do you want to go ahead and present the case?
Yes, ma'am. This public hearing is to consider a request within the Pinehurst Historic District for an exterior modification to include the addition of balconies in the front facade, addition of the new light fixtures to the brick entry columns, and a request to repaint the structure at 5 Community Road. The property can be identified in the Moore County Tax Registry by Moore County PIN number 855-212-976-249. The property is owned by Pinehurst LLC, and the applicant is Calvin Berkeley, a representative of Pinehurst LLC. The Manor Inn was built in 1923 and was replacing the Lexington Inn at the time. The original owner was Mrs. Emma C. Bliss, who demolished the Lexington Hotel and built the Manor Inn in its place. That's significant because she's a historical figure of Pinehurst's early history. She was also the previous owner of the Pinecrest Inn, and she sold that later on to Mr. Donald Ross and his business partner. The inn has been remodeled a few times, including additions to the west side, a rear wing, an extension of the front porch, and accessibility ramp. It is currently covered in vinyl siding. In 2018, the Manor Inn was approved for a COA that modified the following: the configuration of the front entrance, an accessibility ramp, replacement of windows, and modification of some external finishes. Just to reiterate what the applicant is requesting, specifically the applicant is requesting the addition of 2 Juliet balconies on the front facade. The applicant is requesting to paint the reveal in the siding between the 3rd and 4th floor green to match the front door. The applicant is also requesting to change existing globe light fixtures on the existing brick half columns with a walnut bronze metal outdoor pier. This is an aerial view of 5 Community Road. It's located relatively close in proximity to the village center. Across the street from it to the south is the Pinecrest Inn. And to the south, or to the north of it, is Village Mixed Use, which has a lot of different industrial uses. It is located in the historical district, and then it is surrounded by residential properties to the west, Village Commercial to the south, and surrounded by Village Mixed Use to the north and east. This is the rendering provided by the applicant. It shows the 2 Juliet balconies, as you can see there, but I also decided to zoom it in case you guys needed to zoom photo for discussion. This is their existing Juliet balconies on the Carolina Inn, showing that it is congruous with the historic district. This is the color green that they are choosing for the front door to match the reveals that they're proposing. This is the current fixture on the left, which is the globe, and on the right is that walnut bronze pier. They originally submitted a request for a sign permit with this site plan, but they later updated it with this site plan to remove confusion from the application. They are not applying for any sign requests, and it should not be considered. This is a zoomed-in view of that site plan showing the brick entry columns for your guys' review. This is the list of their building material. They are using vinyl, which traditionally is not appropriate in the historic district, but because it's existing material, they're able to continue that use. At this time, I'd like to submit the presentation, application, applicant's material, photos, staff report, findings of fact into the official record. With that, staff concludes its presentation and would be happy to answer any questions.
Are you Mr. Berkeley?
I am.
You're Mr. Berkeley, and you're Perry Harrison. Do you have anything to add to the
Excuse
staff
me, ma'am.
report?
Can you both speak into the microphone? We're not getting on recording. Thank you.
I'm Perry Harrison.
All right, Perry Harrison and Mr. Berkeley.
Yes.
And do you have something to add to the staff report?
Before we can do that, I'd like to know what their position is in relationship to this thing. You're
Oh,
not the owner of the manor, is that correct? Neither of you are the owner of the manor, correct?
I'm the owner's representative.
Okay. And sir, you are?
I am the landscape architect who is the consultant with the resort and worked on the Manor Inn renovations
Okay.
that were previously approved.
Thank you, I'm sorry.
We are expecting the architect to be here, but he was running late, and we were hoping that he would be here in time to add to the discussion.
Well, I think it's also important that we have a representative of the resort of Pinehurst LLC, and that's you.
Yes, ma'am.
Okay, thank
And
you.
you are the director of
Project,
projects.
yeah, Director of Projects and Planning for the resort.
Great. So do you want to go ahead and talk about the additions, changes?
Sure, if, I guess, let's start at, if we can, where,
You're going back.
okay, I'm going to, wrong way, okay.
Big button goes forward.
I'll defer the Juliet balconies, so hopefully the architect can get here and address the architectural feature more. One of the things that we're asking for is to address the reveal that's on the existing siding, and it does go on the front facade and around the building, but it is a I apologize, I'm not that familiar with this. I mean, with the button here. Anyway, but here we go. The front facade, between the third and the fourth floors, there is a reveal in the siding that, after we've done the renovation and made the inside very nice and updated the exterior, it seemed plain, and it seemed the reveal stood out as something that was odd on the siding. It's not something that you would commonly see. And this is an attempt to make it look more appropriate, to break up the white expanse, because it is a large white expanse, and to make it look a little better and to tie it in with the rest of the building, with the muted color scheme, the green of the front door, and it ties also in with some of the interior work that they did. But just to soften it, in essence, instead of just being a harsh white facade. You'll notice in this picture that we do show round globe lights on the columns here, but that's not what we're proposing to use. What we'd like to do is replace that with the fixture on the right. On the left is what's existing. It's a globe light. It's an acrylic globe light. What we found when we were looking for fixtures to emulate what was there on the existing condition, everything was plastic. And what we got, it looks fine at night, but it looks like plastic during the day. And we thought it cheapened the appearance and just didn't look good. We weren't able to get glass. There's not one that was available that we could use. We also tried dressing it up by maybe customizing a collar so it would set differently on the column itself, but that really didn't help. It still looked like a plastic ball. So we went with, we found this other light that seemed more in keeping with the character of the district. It had a nice age look to it, and if you'll notice, it's got sort of a structure that's similar to the sconce lights that's already existing on the side of the front door. So we thought that was appropriate. In terms of the Juliet balconies, again, that's something that we were hoping would dress up the front facade. We have a large white facade that is unusual for the district. I mean, unless you're talking about the Carolina Hotel, the other historic buildings in that area don't have the mass, and the mass that they do have have elements to break up the facade and the massing, so it brings it down to more of a human scale. And as a 4-story building, it does have quite a presence when you are looking at it. It is set a little bit farther off the road, but it still has that presence, and that front facade is a south-facing, so it is getting the full effects of the sun and doesn't really have much to break it up anyway. The Juliet balconies would be similar to the ones that would be on the Carolina Hotel right now, made of wood and metal and possibly Trex, but they would not be usable. They wouldn't be something that the guests would be able to get out and get on. So they're really intended to be decorative and not structural.
Anyone have any questions or discussion?
The staff report raises a question about the Juliet balconies that I wonder if you could address, suggesting that because they are already features of the Carolina Hotel, they perhaps are congruous with the overall historic district, but perhaps not with the architecture of the Manor Hotel. I wonder if your architect has addressed that issue with you.
Well, I wish you were here to address that personally. I know that there have been some architectural changes from the original structure since it was originally constructed. And I can't speak as to the original intent of the design, what the original architect's design plan was or the aesthetic that they were trying to achieve. I do know that there have been significant changes to it, at least in terms of material. Well, I know there have been a couple of additions, and I know with this most recent renovation, we actually removed a wing to be more closely resemble the original footprint of the building, although it is still not the original footprint. I can't really speak to the original intent. I can say that the idea was to to break up the facade. It did appear as a large white mass. Because as you can see, there's really no articulation or decoration on. It's very plain in terms of its detailing. There's no shutters. The windows are plain. It's really the form that is giving it its distinction right now. And this is a way to make it a little bit more decorative, to break up the mass, to bring the scale down somewhat.
Well, I think that painting the reveal between the two floors, between the third and fourth floor, gives it dimension and, a little more form, let's say, takes away the flatness of it. My idea was that by adding the balconies, you were linking it, you were identifying it with the Carolina Hotel and making it, more identifiable as a resort property.
Well,
Did he think about that? That it,
Yeah, I mean, the original, the owner, Mr. Dedman, this was something that he looked at, as the renovations were being done, this was something that he thought would look good, because it is on the Carolina Hotel, but this was actually generated from his thought process.
Are the balconies on the Carolina usable, or are they,
No, sir, they are not.
so they're just like
They're
these?
They are, yeah, same concept, they're just decorative.
because there you really do have a mass to break up. Yes.
Much bigger, yes.
They're actually referred in here to as faux, I think.
Yes.
That was just the word I used. Decorative is the same idea.
Inoperable. What is the bottom going to look like? If you stand underneath us and you look up, is it going to be exactly the same construction method as you did at the Carolina? Because if you've Trex decks on the top, I mean, what is it? Because you're going to punch.
Yeah, the intent
down into
was
some sort of
to,
decking.
yeah, the intent would be to kind of mirror that.
Just because you don't really, going to the Carolina, you're far enough away that you don't really notice that detail here. You would be standing right underneath us and being able to look up and see. So however this is constructed, that's going to be exposed far more visibly than the Carolina.
So I was wondering about that, are we going to be looking at unpainted wood or stained wood? It shows up as a wood color, or is it intended to be painted white?
It's intended to be white.
Yeah,
Okay,
It would be
okay.
painted white.
Okay.
And almost the underside would be more important than the top side of the
Oh,
deck on the
absolutely.
Falcony anyway, because the only people that are going to look at the top side are the ones in that room, basically, and the birds, and the bottom wouldn't. Now, the only intent is those two balconies and the green just on this side of the building.
Correct, that is correct.
Well, the reveal does go around the other sides of the building, but the Juliet balconies are only on this facade.
Okay, so the reveal, you're talking about going around all four sides.
The reveal does go around the other sides of the building.
Okay, I just wasn't clear with whether that was the case or not. Is this who you're waiting for by chance?
Yes, yes, it is.
Molly, you'll need to swear him in.
Yes, well, you're just in the nick of time. If you'd like to introduce yourself.
Yes, my name's Don Tice. I'm with Tice Keister Architects out of Chapel Hill.
And I would like to swear you in, Don. Do you affirm that the testimony you shall give to the commission will be the truth, the whole truth, and nothing but the truth?
I will.
Thank you very much. And you can stand there or sit down as you choose.
I'll stand here.
They've done a very good job of sketching out the design for us. We've just been thinking about the Juliet balconies and the reason for that, and you hope to achieve something that would break up the mass and the kind of plainness of the front facade. So is there anything more you'd like to say?
Well, that's the primary reason. Am I close enough to the mic?
Yes.
I just came running in, okay. The primary reason is the original design, circa 1920s, was a pretty plain and simple box. And of course, there were changes made throughout the ages and some additions done, and the vinyl siding put on and things like that. And our goal has been to try to take it back to more to what it was than what it became in the 80s. There's a lot of horrible things were done to it, the mechanical equipment on the outside, things like that. And so we're trying to be as sincere to the original design as we can. But it is the Manor Inn now, and it is owned by Pinehurst Corporation. They wanted something that looked a little nicer and a little less plain. And the Juliet balconies have a way of, I think, handling the proportions nicely, and they don't take it away. They don't exaggerate anything. It's not like postmodern something. I think they're very appropriate of that time, but honestly, they never were there, so we're not replacing something. This would be something new. And we're not trying to mimic anything, but I think it does give it a nice scale and a nice character. So there is no defense per se. There's just a reason.
Any questions of Mr. Tice? We do have a neighbor who wants to speak, Mr. Mossbrook.
I'm Bob Mossbrook, and I live at 225 Magnolia Road, which is diagonally opposite both the Pinecrest and the Magnolia Inn. And when I got the letter a couple of weeks ago saying that they want to add balconies and lights, to the area, I said, uh-oh, I better get involved. And what I envisioned was having party balconies, all 3 floors. And I got the Pinecrest, which has a big ruckus every night during season from their porch, and then add on to the Manor, and then the traffic back and forth from the brewery. That's what I had in mind, and I'm glad to see the decorative balconies, 2 of them, and they have to climb through a window to get to them, and I like that. I got another concern is the lights. I think there are 4 lights, 4 or 5 of these globes. I think you got some on the edges and everything. And a couple years ago, we had the brick sidewalks and we had 5 street lights, and I sleep on that side of the house, and I can shave without turning on my lights at all. but it has been an increase in density, and I just want to know with the new lights that you have, and they look good, and blends in with the door and everything. Is the illumination or the lumens given out any different from what these globe lights are?
So the simple answer is they would be replacing the fixtures that we've just put on there. It's the same amount of light, so it would be the same.
Same intensity?
Yes, we were just changing the aesthetic of that because they were plastic looking and.
Let me jump
Yeah.
up, kind of add to
Sure.
that, because I disagree with that. It's the same number of light fixtures, but the lumens will be less on these new fixtures because the globes that are there now are pretty sedate in the daytime, but when they turn on at night, they give light all over. What the lights that you've obviously shown that I missed, sorry for being late, the lights that we've shown are more dark sky type lights where they have a top on them, so the light goes out and down and not up. So the dark sky lights and the lumens are a little less, and there'll be a different quality because that white acrylic gives off a pretty kind of LED sort of look, but these will be a little more yellow, so.
Okay.
So it's different quality.
Thank you. Well, it looks like better quality, really. Thank you very much.
Thank you.
Thank you. Thanks for coming. Any further discussion on the application for the Manor Inn?
Could we have Don maybe speak to because you guys had mentioned what the underneath of these would look like?
Oh, and we were concerned about that.
Yes, and I just thought maybe he should speak to that.
Thank you.
The Juliet balconies, they were concerned about what the construction was going to be, and because they felt that on this, unlike the Carolina, you'd be more apt to be underneath and be able to see up to
Which is true.
to the underneath, so they were questioning
Yeah,
that.
when you're coming in from the right side where the handicap parking spaces are and look up, you'll be able to see the underside. Coming in from the other side, not as much because there's a little sunroom addition out there. But yeah, you'll be able to see underneath them. And the underneath, it could be built in whatever way you want it to be. As rendered right there, it's just a solid, painted the trim color. It's just a solid board painted the trim color. But if you wanted it to be more open, they could be. If you wanted it to look more like metal, they could. But right now, it's intended to look more like the wood components, like the rest, wood or stucco. And so it's just a solid, simple surface underneath. But if you think it needed some rustification, it could easily be built out of or made to look like it was built out of tongue and groove or some type of beadboard. Similar, if you walk up there now and as you're walking in, look up in the porch where they have rocking chairs and things out there right now, you look up, that's actually got a beadboard, which is a little thin groove in it. And that same material could easily apply on the underside, which would make a lot of sense historically the way they used to do it. But at this point, it can look however you guys would prefer. It could be smooth, or it could have that rustification with the joint in it, or it could be open grills. I'd recommend against the open grills just because they have a tendency to catch water and drip down and stain things. But it could be built however it needs to be built to make it look the way you guys want it to.
What is the width of the balconies?
They about a width this way or width out from the building? Projecting from the building?
Yeah.
Aren't they about 1'4"? Yeah, 3 North, another group we were working with on this, developed these, so I'm not totally familiar with it, but what I've seen with the images, they're about 1'4" out. So they're really not balconies you participate. I mean, they're strictly for scale and look. And they get enough to give you a nice shadow line like you see in the rendering. I don't know what you guys can see, but I'm looking up at the rendering over your heads.
We got the same thing
Yeah,
right
we
here.
have the same thing.
Okay, very good.
That's why we're looking down.
Yeah.
Okay. I just thought I was boring you. No, but you can see the shadow line underneath. That's about a 1'4" projection to give you a shadow line like that.
Seems like it's another useful place to hang a Christmas wreath at Christmas time.
Or something like that.
That too.
My question was more along the line of, what color are you painting? Is it going to be white underneath there, or is it going to be
Yes.
left raw wood, or?
I would recommend it be white like it's rendered there.
Okay.
I think raw wood would be a little bit contrary to the circa 1920s hotel thing.
Yeah,
So I would recommend it being painted.
and I think the idea of the beadboard matching what's underneath the front would be,
And it's that
a
beadboard is-
thought.
It would last and look good for a long time. It's actually a product called Boral, and it's an eco-friendly product, so in case you're interested. But it's also a low-maintenance product, and it takes paint well. So that's what the existing beadboard is, the new existing beadboard that's up under there now is actually made out of Boral.
Any more discussion on the case? Any more questions? Thank you all for helping us out, filling in the blanks here. Thank you for coming.
Thank you.
I guess we're ready for a motion. Someone ready to make a motion? Richard, thank you.
I'll make a motion.
Okay.
Upon due consideration of the application package submitted and the testimony given, the Historic Preservation Commission concludes the following: that the applicant has satisfied the burden of persuasion and the project as proposed, subject to any conditions imposed by the commission, is congruous with the Pinehurst Historic District and consistent with historic district guidelines.
Thank you.
Second.
Richard Vincent made the motion. Eric Von Salzen seconded the motion. All those in favor of the motion, please signify by saying aye.
Aye.
The motion carries unanimously. Thank you for coming. You have your COA.
You're very welcome. Thank
Looks
you.
good.
The, There you go. Very, not complicated. Our next business is any conversation about the staff approvals, the staff COA approvals.
I
Okay.
have none.
And the final bit of business is our training. We'll just move right into that.
I would make a motion that we close the public hearing portion of the meeting.
Second.
Okay, Tom Schroeder moved that we close the public hearing. John Taylor seconded the motion. All those in favor? Aye. Thank you. Motion carried.
Now the hearing, or now the training.
Now we can have the training.
On conducting an evidence.
It's on the left, bottom left corner, or bottom, usually it's on the left down there. Yeah. You can do it on that one too, that you just brought up.
Evidentiary hearing. My name is David Owens, and I'm a professor at the School of Government at the University of North Carolina at Chapel Hill. To navigate through this module, you can use the left-hand navigation or the play bar that appears below. This module is made possible by the generous support of the Risk Management Division of the North Carolina League of Municipalities. This module reviews how local government boards conduct evidentiary hearings as a part of their land development regulations, a necessary step in making quasi-judicial decisions. After completing this module, you will understand when an evidentiary hearing is required and why. The Normanton Town Council chambers are packed. After months of heated discussion, the council is about to hold a hearing and vote on a controversial and hotly contested development project. Joe, a local developer, owns a 15-acre wooded tract in town. The property sits along a major road in a residential part of town. Joe has proposed a 175-unit apartment complex on this site. The area is surrounded by existing single-family neighborhoods. Many of these residents adamantly oppose Joe's project, objecting to anticipated increases in traffic and potential impacts on the value of their homes. In order to build his apartment project, Joe needs a special use permit from the town. The Normanton Development Ordinance provides that the town council decides these special use permit applications. The hearing on Joe's special use permit for his apartment complex is about to begin. As the mayor calls the hearing to order, it's clear that this is going to be a long night. Joe, along with his lawyer, is present and ready to explain and defend his project. He has what appears to be a half-dozen consultants lined up and ready to testify. The opposing neighbors are also out in force. About 50 of them are in the council chambers, all wearing bright red T-shirts emblazoned on the front with the slogan, "Just Say No," the same slogan that has been prominently posted on yard signs all over this part of town the past few weeks. The clerk just told the mayor that nearly 20 of the neighbors had already signed up to speak. What does the town council need to know and be careful about as it embarks on this hearing? How is the hearing on a special use permit application different from the routine rezoning request that the council usually hears? Let's explore more what it means to do a quasi-judicial decision. Deciding a special use permit is a quasi-judicial decision. All quasi-judicial decisions, variances, appeals of staff determinations, as well as special and conditional use permit applications, require an evidentiary hearing and careful application of due process protections to assure a fair and impartial decision. The process that the council is required to follow for a quasi-judicial decision is very different from the process used for a legislative decision, such as for a rezoning. These different types of decisions are described in more detail in Module 1, Introduction to Land Use. The rules for conducting an evidentiary hearing apply to every board that makes quasi-judicial decisions, be it the Board of Adjustment, the Planning Board, or the Governing Board. Because of the strict legal requirements for evidentiary hearings, Some local governments assign all quasi-judicial decisions to specialized boards, such as the Board of Adjustment. But if the City Council or County Board of Commissioners conduct the hearing, these same strict rules apply to those boards as well. When a board makes a quasi-judicial decision such as this one, it must apply the standards that are already set in the ordinance or in the statutes. The board is not creating new policies, nor is it determining whether the proposed project is a good idea or not. Rather, the board is deciding whether the particular application meets the standards for the approval or not. If it meets the standards, it must be approved. If it does not, it must be denied. How does the board know whether Joe's apartment complex will meet the standards for a special use permit that are set out in Normalton's ordinance? In addition to reviewing Joe's application and supporting documents, the board will hold a hearing to get this necessary information. Under North Carolina land use law, the board does this by holding an evidentiary hearing. As the name of the hearing implies, the purpose of the hearing is to gather evidence, facts, in order to determine whether or not the proposal meets the applicable standards. Unlike other public hearings, the only purpose of an evidentiary hearing is gathering facts. The hearing is not held to gauge public opinion on the popularity of the proposal or to decide what the standards for approval should be. Okay, consider this situation. A local development ordinance can
Yeah, let's go.
assign quasi-judicial decision-making to the Board of Adjustment, the Planning Board, the City Council or County Board of Commissioners, or some combination of these. If the ordinance assigns responsibility to make a special use permit decision to the elected governing board, the City Council or the Board of County Commissioners, does that board still have to strictly follow the rules for quasi-judicial decision-making? On the next slide, you'll be able to select the correct answer, then click the Submit. Since an evidentiary hearing in a quasi-judicial matter is different from the public hearing that is familiar to many people, a quick word about the role of various persons involved with these hearings is in order. An evidentiary hearing is less formal than a courtroom proceeding. There are not formally designated plaintiffs and defendants, but a quasi-judicial matter does have parties. These are the persons whose legal rights will be directly affected by the decision in ways distinct from the general public. The legal term is that they have standing to participate. A party with standing has a legal right to notice of the hearing. They have a right to present evidence and to cross-examine witnesses. Other persons who are not parties have a right to attend and observe the hearing, but only a party has the legal right to participate. Since an evidentiary hearing is less formal than a court proceeding, most local governments allow citizens who do not qualify as a party to present relevant evidence to the board at the hearing. This is permissible, but the board needs to assure that only relevant evidence is presented. After all, the purpose of an evidentiary hearing is gathering factual evidence, not public opinion about the popularity of a project. Let's take a closer look at the roles that staff, attorneys, and board members play. The local government staff plays an important role in an evidentiary hearing. It is common for a staff member to be the initial witness at an evidentiary hearing, usually testifying as to what the ordinance requires, summarizing the application received, and recounting any staff analysis or review of the application. Like any other witness, the staff member is to be sworn in and is subject to cross-examination by the applicant, any other party, and by board members who may have questions. In some cities and counties, the staff also makes a recommendation about the decision or suggests conditions to be imposed, while in others the staff only presents factual information. Either approach is legally acceptable. Attorneys are also increasingly present at evidentiary hearings. The applicant may have an attorney present to handle presentation of evidence and to question any opposing witnesses. Neighbors sometimes have an attorney to represent their interests. The board will often have its own attorney present to advise and assist the board in legal questions that arise in the course of the hearing. In most North Carolina cities and counties, the city or county attorney advises the board making the decision. The attorneys organize, present, and summarize the case, as well as making legal arguments. They generally do not testify or personally present factual evidence. A party's attorney usually calls witnesses and asks them to explain matters, presenting the case for or against a project. If an attorney does testify about the facts of the case, they are treated the same as any other witness and should be placed under oath and be subject to cross-examination. The board chair plays a very important role in managing the process. The chair calls the witnesses in the order set by the board's rules of procedures or standard practice. The chair makes sure the witnesses stick to presenting only relevant evidence and limits unduly repetitious testimony. For example, if a witness starts to ramble unduly or wander into irrelevant areas, the chair can and should interrupt and remind the witness to stick to the presentation of relevant facts. The board rules on any legal objections that are made. As a member of the board, the chair usually votes on the case as well. In short, much like the judge in a civil or criminal case, the board chair plays a key role in maintaining focus and making sure that proper procedures are being observed at all times during the hearing. Individual board members play an important role during the hearing. Board members should be familiar with the ordinance and standards to be applied. They should be knowledgeable about the process and the rules they must follow. They should listen attentively and ask questions to get any clarification needed. As a practical matter, most of the actual cross-examination at an evidentiary hearing comes in the form of questions from members of the board. Board members should assess the credibility and reliability of each witness. Board members also have a legal obligation to conduct themselves with impartiality throughout the entirety of a quasi-judicial proceeding. Finally, it is not unusual in North Carolina for a quasi-judicial matter to be sent to an advisory board, typically the planning board, for review prior to the evidentiary hearing. The report from the advisory board is then presented to the decision-making board. It is vitally important to remember, though, that only the evidence formally presented at the evidentiary hearing can be considered by the decision-making board. Any information received from the advisory board must be supported by factual evidence at the hearing if it is to be used to determine contested facts. Before the Normalton Town Council can hold the evidentiary hearing for Joe's special use permit application, several preliminary matters must be addressed. When a North Carolina local government conducts an evidentiary hearing on a quasi-judicial land use regulatory decision, state statutes set minimum requirements for providing notice of the hearing. While a local government is free to provide additional notice, these minimum steps must always be met. First, mailed notice of the hearing must be sent to the permit applicant, the owner of the property if they are not the applicant, the owners of abutting properties, and anyone else required by the local ordinance to get mailed notice. Some local ordinances also require mailed notice to all property owners within a set distance, such as within 100 feet of the affected property, but that is not required by state law. Second, a notice of the hearing must be prominently posted on or adjacent to the site involved. This is usually done by placing a sign advertising the hearing on the site so that it is clearly visible from the nearest street. The sign must provide reasonable notice to the public that there will be a hearing affecting proposed development on the site. Both the mailed and posted notice need to be made at least 10, but not more than 25 days prior to the date of the hearing. There is no requirement that a notice of the hearing be published in a newspaper, though a number of local ordinances add that requirement. Any additional notice requirements in a local ordinance are binding and must be followed in addition to the state's minimum notice requirements. Under North Carolina law, a party to a quasi-judicial proceeding may request the board to issue a subpoena to compel a witness to appear and testify or to produce specific documents. To have a subpoena issued, the party makes a request to the chair of the board making the decision. The chair rules on the subpoena request and also rules on any objections to a subpoena that are made by someone receiving a subpoena. Rulings of the chair may be appealed to the full board. So far, we have talked about the legal guidelines for an evidentiary hearing, the roles of participating people at a hearing, and now we move our discussion to how the hearing is conducted. Normalton's hearing will go a lot better if everyone involved, the applicant, the neighbors, and the board itself, understand the process that must be followed. While not required by law, Normalton and many other cities and counties accomplish this by having the mayor read a short statement at the beginning of every evidentiary hearing. In this statement, the mayor makes two essential points. One, the standards for the decision have been set and must be applied as written. And two, the purpose of the hearing is to gather quality factual evidence, not opinions, as to whether or not those standards are met. The statement usually goes on to list the applicable standards. This is a good way to remind everyone what information is needed to make a decision and what facts are relevant. The mayor also lays out the order that will be followed in presenting evidence and how the board will deliberate and decide the case at the completion of the hearing. A common hearing order is for the staff to initially describe the ordinance requirements, the application, any information in the file about it, and any staff analysis that has been made. This is usually followed by the applicant's presentation of their case, then hearing from those opposed to the application, and finally hearing any response the applicant chooses to make. When all of the evidence is in, the board moves to deliberation and decision of the case. All of this is done in open public session. It is also a good idea to have a short handout that describes these rules and to make that available to the parties prior to the hearing, as well as having copies available for those attending the hearing and a copy posted on the government local website. Joe is required to present enough evidence to convince the board that the applicable standards have been met. Even though the staff often leads off the hearing with a presentation of the application, the applicant has the legal burden of production. The applicant must produce substantial, competent, and material evidence that the standards have been met. This means sufficient factual evidence that a reasonable person would conclude the standards have been met. If the board concludes that there is not enough evidence presented to find the standards have been met, the application must be denied. After reading her statement about the hearing process, the mayor calls the first witness to be sworn in. What do witnesses and the board need to know about testimony at an evidentiary hearing? The key thing is to remember that persons speaking at an evidentiary hearing are witnesses presenting factual testimony, not citizens expressing their personal opinions. That distinction is made clear by requiring each witness to be sworn in, to take an oath to tell the truth, the whole truth, and nothing but the truth. Everyone presenting factual evidence to the board needs to be sworn in, the applicant, staff members, consultants, and neighbors alike. Witnesses with religious objections to an oath can affirm instead. The oath reminds witnesses that this is a serious, solemn process. Deliberately giving false testimony under oath makes the witness subject to a criminal charge of perjury. Oaths for witnesses can be administered by the board chair or the clerk to the board. Some boards administer the oath to each witness at the beginning of his or her testimony, while others swear in all of the witnesses prior to the hearing. Either approach is permissible, but the board chair should verify that each witness has been sworn in at the outset of their testimony. Only parties to a hearing have a legal right to present evidence to the board. They can testify themselves or call witnesses to testify. As a practical matter, most boards allow anyone present to be sworn and to offer testimony as long as the testimony is relevant to the standards for decision and is not repetitive of evidence already in the record. There is one exception to the rule that witnesses must present facts, not their opinions, to the board. An expert witness is allowed to present their professional opinion about two issues that often arise in land use disputes: the impact of the proposal on property values and the impact of traffic expected to be generated on public safety. Only a qualified witness who has conducted appropriate studies to form a professional opinion is allowed to offer opinion testimony about these issues and any other issues that would require an expert witness in a court proceeding. Parties have the right to cross-examine each witness. The applicant can, for example, ask a neighbor who is testifying how they arrived at a particular conclusion. As a practical matter, most cross-examination comes from members of the board who often ask for more details or seek clarification about testimony as it is given. Parties also have the legal right to present rebuttal testimony. For example, the applicant is given an opportunity to respond to evidence presented by opposing witnesses. Okay, consider this. In the typical quasi-judicial hearing, parties and staff will present evidence to the board. Can an interested citizen who is not a party to the case present evidence and ask questions of the witness? On the next slide, you'll be able to select the correct answer and then click the... Okay, consider this situation. A common standard for special or conditional use permits is that the project not have a substantial adverse impact on neighboring property values. Often testimony on this issue is provided by experienced real estate professionals or appraisers. It is also common for neighbors to offer testimony about property value impacts. On the next slide, you'll be able to select the correct answer, then click the Submit button to receive feedback. When you're ready to move to start the quiz, select the Continue button.
What was the question? Oh, there, okay.
Not unless the neighbor's a realtor.
They're not a professional, right?
The correct answer is no. A neighbor can testify as to objective facts that may affect property values, but the board can only rely on an opinion about property value impacts if that opinion is offered by a properly qualified expert witness who has done the appropriate studies upon which the opinion is based.
You may continue with... In addition to verbal testimony at the hearing, documents are an important part of the evidence to be considered by the board. The application, any supporting materials, any staff reports, and any other documents that have been received need to be formally entered into the hearing record. This is usually done by staff making the initial presentation to the board. A witness may also present relevant documents to be made part of the hearing record. This includes photographs, letters, charts, reports, technical studies, and the like. Each exhibit that is presented should be numbered and kept by the hearing clerk as an official part of the hearing record. All of the parties have a right to inspect documents entered into the record, and time should be allotted for that if the party has not previously had access to those documents. As a general rule, it is preferable that the person who prepared a document that is submitted as evidence is present to testify as a witness. That witness can explain how the document was prepared, what it contains, and is available to be cross-examined, answering questions about the documents that another party or that a board member may have. A document can be received into evidence even if that author is not present to answer questions about it, but that absence may limit how much consideration the board can give to the document. That is because there are limits on the board's use of hearsay evidence. It is hearsay when a statement that is being used to establish a fact has been made by a person who is not present at the hearing. The classic example would be a witness testifying, "Mary Smith could not be here tonight, but she has lived next door to this site for 20 years, and she told me last week she had never seen traffic back up at that intersection." Since Mary Smith is not present to testify and answer questions about what she has really seen, that would be hearsay testimony. A board can receive hearsay testimony, but it may well decide to limit the weight accorded to it, and a board must not make a critical factual finding solely on the basis of hearsay evidence. Okay, consider this. The hearing record in a quasi-judicial matter often includes written documents prepared by persons who are not present at the hearing. Can the board consider and rely upon these materials if the author is not present as a witness at the hearing? On the next slide, you'll be able to select the correct answer and then click the Submit button to receive feedback. When you're ready to move to start the quiz,
The correct answer is B. If the board considers written documents that are part of the hearing record to be accurate and reliable, they may be considered in making findings. However, if the board would like to cross-examine the author or receive additional information, the hearing can be continued to allow that to be done. If the board questions the reliability of the documents, it should accord them no weight in making its decision.
you may continue with the module by selecting Continue. There is a somewhat similar limit on ex parte evidence. This is evidence gathered outside the evidentiary hearing. Each party has a right to hear all of the evidence that is being considered by a board member. If a board member has a conversation with a person about the case prior to the hearing, the parties and other board members do not know what was said and have no opportunity to ask questions or rebut what may have been offered. So the law prohibits board members from seeking or receiving evidence outside of the hearing. Board members should not seek facts about the case from the staff, the applicant, the neighbors, or anyone else prior to the hearing. All of the evidence to be considered needs to be presented to everyone at the hearing. This rule is sometimes difficult to observe. Joe might want to meet with a board member for lunch to talk about his apartment complex. A neighbor may see a board member at a social function and want to chat about the upcoming hearing. In both instances, the board member needs to politely but quickly cut off the conversation and let Joe and the neighbor know that the law prohibits a member from receiving any evidence outside the hearing. The board member should also encourage them to come to the hearing and present factual testimony there for the benefit of all involved. A board member should disclose at the hearing any ex parte communication that has been received. Sometimes a board member will have personal knowledge about the site or the development proposal. It is appropriate for the board member to use that prior knowledge, but the board member should disclose it during the evidentiary hearing. For example, a board member could note for the record, "I am personally familiar with the traffic conditions at that intersection. I drive through it several times a day. Just last week, traffic was backed up there for 5 minutes when I drove through." With that statement, all the other board members and the parties are made aware of the fact and can ask questions and have the opportunity to rebut it. Some board members want to make a site visit to view the property prior to the hearing. This is permissible, but the members should state at the hearing that they have done so and should set out any particular relevant facts that they observe. As with board members' personal knowledge, this puts the facts on the record and provides an opportunity for the parties to ask questions or to rebut the evidence. Okay, consider this. One of the general rules for quasi-judicial decisions is that only evidence properly in the hearing record can be considered by the board. Board members often have personal knowledge about the site or proposed project and may hear about the case outside the hearing. Is it permissible for a board member to consider outside information or prior knowledge in making a decision? On the next slide, you'll be able to select the correct answer, then click the Submit button to receive feedback. When you are ready to move to start the quiz,
The correct answer is C. A member should avoid gathering any evidence outside the hearing and must disclose any outside information or evidence that was received. Objections to improper participation can be made at a judicial review after the decision is rendered. It does not matter if the member's vote actually affected the outcome, since participation, even in the discussion of the case by a member who failed to disclose ex parte communications, taints the entire process and will result in invalidation of the decision if there is a court challenge.
you may continue with the mod.
Talk about that, because that's a little different for us.
It is,
The
because
statute says we can actually go to the site and review the site.
in fact, it is recommended that we go to the site.
Absolutely. Well, the statute just says we can't. It says you can go to look at it. But at any rate, we have the right to go look at it. But that doesn't relieve us from the other option, the other requirement to actually put that on the record at the hearing. If we go to the site, every one of us that goes to the site would have to put on the record, we went to the site. It would be good if you had a date at least, but not necessary. But you went to the site and a quick 1 or 2 sentences about what you saw, because it is still ex parte information, even though the statute allows us to do that ex parte information. So we are actually bound to going back and putting on the record that we went there. Otherwise, just as it said it there, I think we're at risk of being overturned on any appeal, even if it doesn't affect, as it said there, even if it does not affect the outcome of the evidence, because all they would have to show is that failure to disclose the fact that you visited that site would taint the whole case to the point where the court could invalidate the decision to go do this.
See, to me, this is excessive. However, perhaps what we should do is, at a point, ask the commissioners who went to the site.
Right.
And we just make a list of those who went to the site.
That's
And maybe that would be adequate. This kind of consideration has never come up before. And to me, it's not really relevant to us, because our traditional behavior in preparing for a case is definitely make that site visit.
Right.
Because that gives you information that
The
you're not going to
statute
get
clearly says-
any other way. And you're making it, you're not having conversations,
No,
you know,
you
with
can't.
the,
That's
with
the
the,
other part we
with
need
the,
to be
with the
careful.
carpenter.
You go there, don't talk to anybody.
Well, and if you do talk, then you disclose that. But if you're just eyes on the site, eyes on the neighborhood, judging the compatibility of things, that is absolutely part of our,
Well, it is.
responsibility.
I agree. I'm not arguing that. My only argument is if you saw something that wasn't disclosed at that hearing, that's when it becomes an issue. I mean, they would obviously have to show that to be able to get the court to deny that, but the real issue is what you saw to go do it.
Except that we do disclose what we saw in the discussion of the case.
As long as we do
I
disclose
mean,
it.
we do, because that's one of the reasons to have the discussion. We all kind of pool our knowledge about
But I know
what we
I've
saw.
gone to sites and I've seen things and I've not even disclosed the site visit or what I saw.
Well, as I say, it's something that's not been done before.
I'm not arguing that it hasn't been done before. I absolutely agree with you.
Our questions, as they come up in discussion, could just be a function of, as I think Eric's was earlier today, I note that staff noted the following issue. Well, you didn't have to go to the site to note that, and I'm not sure that we're always as specific why are you asking that question? Well, I'm asking that question because I actually went out there, and it doesn't look like the drawing.
I think the primary concern that I would have is, one of these days, we're going to get a controversial case that's going to go up on appeal, and we don't want to give the losing party an easy win. And I hadn't thought of it before hearing this, so this is worthwhile. But I think part of our routine could very well be simply each member of the commission stating whether or not he or she had made a site visit for that particular property. I mean, I almost always drive by the property, don't usually stop and walk around it because I don't need to. The photographs that we get and the materials that we get from the staff are really enough for us to understand what's going on. But still, you feel better having been able to say, I looked at it. And that's, so to avoid giving a
Question you because they knew you drove by or you actually went there.
Yeah.
If they didn't know you went by, they had no knowledge that you went there, so they couldn't question what you saw.
But it seems
But
that...
I'm going to argue with you a little bit, which is part of our responsibility is to understand how this new project will fit into the neighborhood.
Oh, great.
So you need to...
Not the neighborhood,
take-
into the district. Right
Well,
words.
to be congruous with the surrounding homes, let's say, the surrounding properties.
Okay, I understand your point.
But you understand what I'm trying to say.
Oh,
So you have to, and you don't get that. You don't get that from the
I
staff
absolutely
materials.
agree, we ought to go look at it. There's no question in my mind that that's what should be done. We ought to at least have a working knowledge of the location and where it is in the district and overall what it looks like, because there's no difference there. Just the fact, though, that if we go there, it should be on the record, because that gives the other participants the option to ask questions about what we saw. If they don't know we went there, and upon appeal, it's not shown in the record that I went there, and I'll use myself, then that's enough to overturn that case right then and there, whether I open my mouth in the whole proceeding or not, or if I even recuse myself from voting on it, it's probably enough to overturn that case because it impinged upon their due process. They didn't have the right to ask about some of the information I may have been using in that case.
Would that presumably be only if we denied an application and therefore the person bringing it, or could it also be we approve something
Either or.
and someone who spoke against it, or maybe they didn't, maybe they were just in the audience?
If they could prove standing to the court,
Right.
which they may or may not be able to prove, but if they could, by all means, all they would have to do is show that one of us went there and didn't put it on the record.
I mean,
So what we need is a vehicle for showing that we made site visits,
Yeah, just
And-
make us go.
After you swear everyone in, who's been to the site, bum, 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 bum.
Yeah, well, we don't need to be sworn in, we just make a statement.
At the
Tom, have you
beginning
been
of
to the
each,
site? Yes.
at the beginning of each COA, who's been to the site? Show of hands so that it can be recorded.
Right. So that the other participants, we aren't a participant, they're a participant, so the participants know that we've been there and therefore have knowledge to be able to ask us questions about, well, what did you see? What information are you doing? Which is the biggest issue on ex parte communications is you're not supposed to do it, but should you inadvertently go to a site and talk, and the owner sat there and said, and you talked to them, you shouldn't do that. But if you do it, the corrective action for that is to come back and make that statement known at the file.
So should we add to the, have you been to the site question, did you have any communication?
It's usually some kind of summary of what you saw.
So two elements here. Did you go and did you talk to anybody?
And that can be recorded and put into the minutes.
So, absolutely.
It'll reflect that 5 of you didn't go and 2 of you did.
Because the real issue is violation of the participants and the applicant, in most cases, the applicant's due process rights. If they didn't know you were there, they can't ask you a question about what you did or see or what you were applying from what you saw to go in there. They have to have that right to ask that question and have knowledge of the fact. Even though the statute says we can do it, and we all agree, I think, that we should do it, at least drive by or something to have some knowledge of what it is, it doesn't relieve the due process rights.
It cannot even be questioned. After reviewing this, we know we have to be doing this. Even if it hasn't been done and we haven't been caught, it's insurance. Think of it as insurance policy. No one wants to have it, but you're thankful when you have it in that one time that you need to go and file a claim. So that's insurance for us. I mean,
And either party, either the winner or the loser, can challenge it in court. The one that wanted the COA, if they didn't get it, can challenge it, or if somebody who had standing could file an appeal.
that's what you're going to see it mostly from upset neighbors, from disgruntled folks. I mean, that's where you're going to see this. And actually, if you think about it, if the public was aware of this and knew that this was a duty of ours to disclose in these quasi-judicial hearings, once it happens once, it'll happen 10 times after that. So you just kind of need to open Pandora's box there.
The thing that I think is important is that the site visit, leave aside an actual discussion with the property owner, because we would know that we want to avoid that. But the site visit is something that we are proud that we have done. We're not admitting that we've done anything wrong, and indeed, it should give greater confidence to both the applicant and any other people who are here to know that we've taken the trouble to go by and take a look at the property.
And if it's a house half a block down that you drive by every day, you should acknowledge that too, just as they did in the traffic example here. You know, it's 2 blocks away. I know nothing about it. I'm not going to, I don't believe I need to recuse myself. But I drive by it every day. And I see the traffic, or I see the fact that it's painted purple, or what big scopy things that you look at would be the case. But it should be, if you have knowledge that's external to here, you have to acknowledge the knowledge at this hearing, because remember, the decisions are made only on what's presented at this hearing, just like in a court of law. I may know something out on the outside, and I can't use that as information to make a decision on.
So I have a question. Is proper disclosure just bringing something up in the course of discussion? Or do you have to announce, I am making a disclosure? Because what happens is the things that you know, the things that you discuss, the questions that you ask, the points that you make, the observations, it comes from making that site visit.
Right.
That comes from outside information. You share it in the course of discussion.
Right.
And so my question is, do you have to formalize that?
It's kind of a safety issue. If you formalize the fact that you went there, now they have reason to understand why you're asking the question you are, or making something to it.
It sort of came up last meeting. In the application that Bart Boudreau made, that did not have dimensions on it.
Yes.
And I think, at least speaking for myself, I reached the conclusion it was okay to approve it based on my knowledge of past work that he has done, which has been of high quality. And eyeballing it, it looked like it was okay. It would have been better to have dimensions on it. That would have made it clear for everyone, as well as for Peter or staff when they actually went out to see what was being constructed in accordance with the COA.
But see, your decision of his past experience,
That's not.
you can't use that, because it wasn't brought up at adhere. I mean, you're taking information from outside unless you state what that very fact. I've seen 15 of this guy's projects in there. But then it still goes back to each case is heard on its own merits, which is another whole argument, but you can't use, well, he did it great this time, doesn't mean he's going to do it great this time.
But I can't partition the fact that in the course of life, I've driven past possibly every house in Pinehurst.
Right, and that's right.
And even if and 2 years later, they come before me, and I have no idea whether I'm actually remembering that, or am I
No,
going
no,
off
and it's not to that point, but if you just at least acknowledge that you went there
Oh, of course.
as part of the preparation of this,
Right, which
I don't-
that's the part you got to get to. The fact you drove by it 6 months ago,
Yeah.
I don't remember driving by any house 6 months ago.
Now, but if as part of our job, and we think it is part of our job, we go to the property and we look at it, it should be a routine thing that we acknowledge that we did, or we didn't. We didn't get a chance to see a particular.
And that's okay. It's not required
Put it on the record, and therefore
That's the
nobody
key.
can say that we've,
that it was,
And it's pretty straightforward for us to do that. It
Right.
will not lengthen meetings materially.
no, they just go right around and, yes, I went there, and
45 seconds. Yeah, BOA does it. Jane Hogeman, Councilwoman Jane Hogeman did it at our special permit for ABC. She disclosed that she frequented the ABC store.
I have been to the ABC.
It's as simple as that, where she decided to disclose that because it could impact her.
if I was there 3 years ago for a cup of coffee, I wouldn't worry about it.
That's different.
But if I was there 3 days ago, if I just bought something out of the ABC store 3 days ago, that's probably something. There's no real black and white. It just has to be a little bit of common sense.
It's a protective move. It's smart to do it. I don't see us having a choice. We should be doing it anyway. So when do we want to do it? When you announce everyone here to achieving a quorum, and then we go into the first case?
Well,
and
you
then
have to
would
do
say-
it for every
You have to do it
case.
for every case.
COA by COA.
Obviously, and then you would say, as you introduce everyone, swear it in, and then you would say, let me go to the members here, who's been to the side, and then we disclose. Okay.
We could even do it when I call for discussion. You know, you make your presentation.
It's easier to do if you do
Right up front, then you don't forget about it.
That is true. You can just put it on the
Put
slide
it in
before
your-
you swear me in or before.
Can even be in the template on
We
the,
need to do it case by
Case.
case, so each time we have a case.
Yeah, no, I'm just saying.
He does his spiel, and then right after his spiel, would go around and say
We'll
yes, no,
remind you.
yes, no, yes, no.
You always
Shoot, Peter, this was useful. Okay?
I was just kind of closing my.
All right, Kelly, I'm sorry.
oh, wait, I like this, I like the next one, closing the hearing.
Some boards close the evidentiary hearing and then begin deliberations.
Gotcha.
The difficulty with this approach is that questions may arise in the deliberations that need additional evidence or further clarification of the evidence that has been received. If the hearing has been closed, no additional evidence can be taken. So while a board can move into the deliberation phase of decision-making, it is best not to close the hearing before taking a vote on the matter. If the board determines that the
this does not require that we move out of the public portion of the hearing. Because we typically don't.
Right, and we shouldn't, because if we have a question during the deliberation and you've moved out of it, then you got to move back into it again, I think. So I think the answer is you open it up to public hearing, we get through the deliberation, and once we're done with the deliberation, and I think in our case, because everything is the same, we start with an open hearing here, and 5 cases later, we end it over here.
We effectively do our deliberations as part of the open meeting, so we have not closed.
Yeah,
Other than
because,
once we rule, then we're not going to listen to anyone else coming back 20 minutes later to.
correct, that's the point. But you can, I guess, open it, go all the way through deliberation, make our motion, pass our motion, yes or no, and then close it, and then the next motion would be to open it for the next one.
I think this is more applicable to the village council and what have you, but.
So you could, I think, would be acceptable, but I think it's kind of clumsy to go
I agree.
in, do everything for that case, go out, and then turn around the next motion, open it back up for another public hearing. I'm not sure what you do.
Yes, it was awful.
Yeah, it is very cumbersome. And I don't think, if I could think of a reason why we ought to do it that way, but I can't even think of a good legal reason why you would do it.
Would be if we had a problem when we're having our deliberations, people in the audience jumping up and saying, well, now, wait a minute, Tom, what
Oh,
you
well,
just said
then-
is a bunch of BS.
Yeah,
Because
well, that's-
right now-
They're going to say that a lot.
But,
That would be,
In his
that would
case,
be
yes, but-
Molly's point to shut that down.
but
Without, you wouldn't have to make a motion to close that down.
we haven't had that problem, let's not invent it, you know.
It's never been you, Tom.
Parties need additional time to present more evidence, the board can continue the hearing to a specified later date. If the date, time, and place of the continued hearing is specified before the hearing is closed, no additional mailed or posted notice of the additional hearing date is required. When the board is ready to decide the case, it must determine any contested facts, adopt written findings of fact, apply the relevant standards, consider conditions of an approval, impartially apply the standards, and take formal action to decide the case. The rules for deciding a quasi-judicial matter are discussed in detail in the module on making a quasi-judicial decision. There is one last important part about the evidentiary hearing. The local government must maintain a complete record of the hearing. Detailed minutes of the hearing are required, including identifying all witnesses and a summary of the substance of their testimony. A verbatim transcript of the hearing is not required, but an audio or videotape of the hearing must be made and kept as part of the hearing record. If a party making an appeal of the decision to court wants to do so, they may include a verbatim transcript in the record on appeal, with the cost of doing so being the responsibility of the party requesting it. If there is a judicial appeal, the clerk to the board compiles the official hearing record and provides it to the court and to all the parties to that suit. Welcome to this module on making a quasi-judicial decision.
How much more is
My
this
name is
gonna be?
David Owens, and I'm a professor at the School of Government at the University of North Carolina. Deciding a special use permit is a quasi-judicial decision. All quasi-judicial decisions, variances, appeals of staff determinations, certificates of appropriateness under a historic preservation ordinance,
For a second.
as well as special and conditional.
This is more like a 20 to 25-minute module. I don't think it's great to break it up.
I've got to be somewhere at 6.
Well, if you guys all gotta be somewhere, we can listen as far as we can, and then
Yeah, but it's,
you guys will have to close the public hearing.
Tack it on to the next one, if it's only 20, 25.
the next one we got a break on, just, we can bring it each time to kind of,
Yeah, that's fine.
if we got an extra time the next
What is
time.
the forecast for the next meeting, the next formal meeting?
Next formal meeting is February 27th at 4 PM. We'll probably be hearing the case over the advance
It looks, it's only one that you're aware of at the moment.
at the moment. Only one.
That might be a good time to go to this next module.
I would propose informally or move formally that we table this section
Second.
and do it all as a single.
We could, and the other option is that you can send us a link and we can do this at home. Because Kathy,
Think we don't,
because Kathy did that for us, I remember.
oh, maybe, I don't know. I don't know whether you can download them or not.
It was through, was it?
Take a look, if you can, it'd be good to send it to us.
Duke. Was it Duke or UNCW?
No, it was this, it was the
Okay.
School of Government. It was the UNC.
Yeah,
Okay.
I think that's right.
Let's do it the next session.
Yeah, but it wouldn't hurt for us to review it ahead of time either.
That's true.
So how many modules are there that you've identified as useful?
Basically these two, because you guys are an evidentiary hearing process, and then your quasi-judicial body. Like, those make the most sense, it's all procedural. That's the reason why we're watching it, is that you guys, and myself, make sure we're doing everything right, so we don't get.
Are we going to have time off to the Menzo one?
I don't know.
There is one question I think we do need to answer. That's your 13th question.
Oh,
There's a
Yes.
potentially a request for a second February meeting. I believe we all got an email over that.
So
Lee Manzo presented to council on January 7th about her frustration with this historic preservation process. And they just want to know if we could extend any courtesy to a special meeting if possible. That still means that Ms.
Who made that request? The council?
Council and Ms. Manzo. We're looking about how we can.
The village council, not attorney council?
Yes.
Okay.
But Ms. Manzo would still need to present all of her material for a new COA, and whether or not she can get that done by January 1st is great, but we could still offer,
By February.
sorry, January 31st, my bad, 31st, because I would need at least that time to notify properly and
To
everything.
do the
like that.
postings and stuff, yeah.
So,
We have worked so hard to give Lee, her COA without another meeting, and without another fee. And it has been such an extended process, mistakes on both sides, I would say. I mean, I think we all could have done better, staff could have done better by her.
I think she was a victim of timing. I was transitioning in, Kathy was transitioning out, so she didn't necessarily get.
I will do my best to be here on the 13th, but there's a possibility that I won't be available. I won't be in the county.
Well, we need a quorum, so we need
Right,
five.
that's why I'm
We
saying,
need five.
I can
and,
be here if needed.
So that's
There's
two,
two.
3, 4, I guess that's everybody. You can't, so 1, 2, 3, 4, 5. Like, we only need 4 to show for.
That's right, we need a, yeah.
Well, we have 4 plus possibly Eric.
But we need
Terry.
5 to say, just in case Tom can't make it.
I mean, the worst case you do is you try it, and if you don't get the quorum, you don't get the quorum. I mean, there's nothing you can do at that point.
Yeah, that is true too. My guess is that she won't be able to get everything that she needs because she'll need a full set of elevations and,
So if she has everything she needs,
yeah.
We'll
I'll let you guys know the 31st.
Because she is ill-served by her builder.
Yeah, she's been back 3 times and she's never had all that she
Herself
needs.
without a builder
Yes,
or a.
yes. And then she brought the builder, and the builder turned around and looked at us and said something to the effect about, well, they haven't decided what color to paint the thing
Right.
or something. There was a distinctly
Okay.
glaring hole in the.
If you miss the 13th, it's a 2-week wait.
It's purely a courtesy that we're doing.
We can try it. That's the best we can do.
I just wanted to
From a
make-
formal hearing standpoint, we have notification to neighbors and what have you that has to go out.
Right.
And that's why I have to know by January
It's 31st. So if he doesn't,
Because that gives me that day to get notifications out for 10 days.
well, is this is a whole new hearing, or is it a continuation?
It'd be a whole new hearing.
Okay, well then yes, you absolutely need to make
Yeah,
that.
we couldn't amend it.
Right.
I'd like to be here for this one.
I'll do my best to be here, because I want to see it too.
All right. On that note, Molly, will you close the hearing?
Oh,
Motion to
Molly?
close the public hearing.
I second it.
So I had
No, that isn't
a motion from Richard Vincent, yeah.
I was going to ask one question. Sorry to keep you guys for 30 seconds. You can go, Molly. Peter, when that person stood up and talked about lights and illumination and lumens and output, do we let someone ramble on like that, or do we say, look, we have no standing, this is not our authority to purview, and they started talking for 5 minutes about the light and light pollution? That's got nothing to do with us?
Technically, that doesn't have anything to do with you, but.
That it still continues?
Yeah.
Not standing.
Well, not necessarily did he have a legal standing.
He was able to ask questions to the applicant who has a professional experience in dealing with illumination, saying.
Yeah,
hey,
but
is it
that's-
gonna be less or more?
But do
The
we
legal
say that-
standing is his,
Whether or not it was relevant.
Yeah.
well, the legal
Say, hey,
standing,
that's not the right forum for this, that's a staff, that's with the staff.
and the answer, I think, would be, typically, we let anybody speak.
Okay, they
We
got it.
just have to be careful not to use information from somebody who isn't qualified to make that. I mean, he started talking about looms and so on and so forth, and unless he's an engineer, I doubt he has any qualification for that kind of there. And even if he did, he would have to identify, or we would have a right to ask what his qualifications are before we took that into factual evidence.
And he would need to have had a report prepared.
And he'd need to have a report prepared
Or
as
just
to.
stamp and say they're gonna be too much, you'd have
That's
to
right.
have had something that is factual to present.
Yeah, so, I mean, we let them do the hearsay,
them go.
or the,
No matter how simple, you can always complicate it.
Yeah.
Some of us may want to run for political office sometime. You got to be nice to your participants. Right?
That's the goofy thing about,
Of that.
We'll need a motion to close. Oh, sorry.
we did, we haven't voted on it, though.
Motion to adjourn. Need a motion?
Second.
Okay, so I guess I made the motion.
That's okay.
All in favor? Aye.
Aye. Now we're.